my name is Joe Bartolomeo. I am a Social Security disability lawyer. I am based in Oregon. I have offices in Hillsboro, Oregon, and I have an office in Astoria. That's my base office, my home base office. And in today's video, I'm going to talk about the vocational expert in the Social Security disability hearing and give you a summary of what it is they're there for, who they are, what they're talking about. Now, I have another video that goes through what happens at a Social Security disability hearing. It covers this topic generally, but in this video, I want to take a little bit of a deeper dive into this particular witness and their role at the Social Security disability hearing. If you have other questions about Social Security disability claims, I will leave a link for my ebook. It's a free ebook that I offer through my website. I will leave a link for that on my YouTube version of this video. I will also leave you my contact link should you have any questions about Social Security disability in general. So let's talk about the vocational expert. Every Social Security hearing that I've been to, just about, there's always exceptions, includes a vocational expert. The vocational expert is an independent contractor that does not work as an employee for Social Security. They're not a Social Security Administration employee. They are an independent contractor, and they come in to the hearing more recently, and the trend has been they testify by telephone, but they appear at a hearing to testify as an expert witness on vocational issues. These witnesses are vocational counselors, so they are counselors that focus on vocational rehabilitation. For example, in my workers' compensation practice, I may have an injured worker who is unable to return to their job at injury, the job they were doing when they were injured, and they may work with a vocational counselor to train for a new type of job. So that's what a vocational counselor does in their profession. As an expert, they're giving opinions about a couple of different things, and we'll talk about that with testimony. But before we get into that, I'll tell you what I tell my clients in a pre-hearing appointment, and I just had one today, and that's what made me think of doing this video, is the vocational expert is truly a neutral expert. They do not have any skin in the game. They do not have a dog in the fight or any other cliche or saying you want to give it. They're going to be paid their fee regardless of the outcome of the case, and they really don't have any bias one way or another. They're there to give their opinion, and that is it. So let's get into what they're talking about, and then after that we'll talk about why their testimony is so important. Okay, so we're going to talk about the testimony of the vocational expert in this part of the video. So there are two things that a vocational expert is going to testify about at a Social Security disability hearing. The first one is really not often very much an issue in the case, and that is past relevant work. What is past relevant work? When you apply for disability, you put a date down on your application saying when you became disabled. That is called the alleged onset date, the date you became disabled. What a vocational expert will first talk about is your past relevant work. Past relevant work is all of the work that you did in the 15 years before the date you alleged your disability began. So if you alleged an onset date of January 1st, 2015, the vocational expert is going to go through your file, and they're going to talk about all of the jobs that you did from January 1st, 2000 up until the date you're claiming your disability began. And there are two things that they're going to focus on. Number one, what were the physical or exertional requirements of those jobs? How much did you have to lift, carry? How long did you have to stand, sit, walk, reach, climb, all of that stuff. And then the other thing they're going to classify or describe is the skill level of the job. Now, there is a document out there in the world, I believe it's authored by the Department of Labor, and it's called the Dictionary of Occupational Titles, or the DOT, and that is a catalog of jobs. It's kind of outdated, but it gives descriptions of jobs, and it includes skill level, and it includes exertional levels. And the vocational expert will talk about what the skill level is. Now there's unskilled work, semi-skilled, and skilled work. And then there's a description in this dictionary that is called specific vocational preparation. And there's a ranking on that. And basically that is how long does it take to learn this job? And so it's kind of a more specific description of skills. So that's the first part. Now, usually this isn't a big deal, but sometimes it can be a game changer on your case, because you may have worked a job that is typically not that physically demanding, but the way you did it, it's much more physically demanding. And depending on other factors, including your age, that could be a decision, factor. That could be a game changer. It could really determine whether you win or lose. But most of the time, it's pretty much whatever it is. You did this, you did that, here are the skill levels. So after that's all done, then we really get into the heart of the testimony of the vocational expert. And this requires me to give you a little bit of a setup. So what the judge is going to do in the second part of the testimony is the judge is going to go through your file. And the judge, if they're a good judge, and there are a lot of good ones out there, if the judge listens carefully to your testimony, they'll also draw from that. And then what they're going to do is they're going to come up with different scenarios of what your residual functional abilities are. What does that mean? That means, what are you able to do in a work setting? How long can you sit, stand, lift, carry, walk, reach, crouch, crawl? All of those things. Can you do light work, medium, heavy? And where they're getting these scenarios is out of your file. So we know that if you're at a disability hearing, there are at least 2 opinions that feel that you're able to do some kind of work. And there's a description of the physical abilities that you still have, in the opinion of a doctor, to do work activity. So the judge is going to use those opinions and form a hypothetical question that will go something like this. Please assume that we have a person who is the same age as the claimant, who has the same educational and work experience as the claimant. And this hypothetical individual can do light work. They can stand this long. They can sit this long. They can reach this much. They may have some trouble with environmental issues like cold or heat or fumes or dust. They should not be around hazards. Or if there's a mental health disability, they might say something like, this person should do simple and uncomplicated work. They should not work closely with others. They should not work closely with the public. They should only have brief and intermittent contact with supervisors and coworkers. And then they'll say, after they form their hypothetical, then the first question is, can this hypothetical individual do any of the past relevant work of the claimant? And there you go. That's why your past relevant work is a big deal. And the vocational expert will say yes or no. And then if they say yes, they'll describe the jobs that hypothetical individual can do. Then what happens is the judge will say, if the vocational expert says, no, Your Honor, this hypothetical individual cannot do any of the claimant's past work, then the judge will say or ask, are there other jobs that exist in significant numbers in the national economy that this hypothetical individual can do? And the vocational expert will say, why, yes, Your Honor, there are. Here are some examples. And then what they'll do is they'll describe at least, usually it's 3 jobs. They'll give the title of the job. They'll give the code number from that dictionary of occupational titles that I was talking about. They will also give the number of jobs that exist in the national economy, and they will give the skill level. And then the judge will ask for more examples, and they will give all that information again. Title, skill level, number of jobs that exist in the national economy. Then the judge will ask another hypothetical, and typically what they're doing is they are increasing the limitations that the first hypothetical person had. So they might say, instead of this person being able to stand 6 out of 8 hours in a day, they can only stand 2 hours out of 8 hours in a day. And when that happens, it may affect the jobs that the vocational expert identifies. Now, at one point in the hearing, the judge or your lawyer may ask whether a person could do any kind of or participate in any kind of competitive work if they were missing 2 or more days a month, or if they were off task 20% of the time or more. Those kinds of questions will always get an answer that the hypothetical claimant cannot do any kind of competitive employment. And really what those questions are intimating is somebody who cannot show up on a regular basis. If you have a medical problem that would cause you to call in sick more than a couple times a month, or if you would be off task, maybe you have to go and put your feet up for a couple hours in the afternoon, those are the kind of limitations that will prevent you from being able to do any kind of competitive employment. Some judges will ask that question themselves. If they don't, I will. So that's the vocational expert's role in the Social Security disability hearing. Now again, I have a video that really goes through in great detail the whole hearing and gets into this as well as many other issues. I also have the guide if you'd like to download that. If you have questions, contact us, call us. I'll leave all that information below with the YouTube version of this video. I hope this is helpful for you. Again, contact us with questions. Thank you so much for watching. Take care.